Hello there. It's another Monday, and the program is Law and You on Independent Television. My name is Adesuwa Osa-Uwagie. Today on Law and You, we are going to be looking at the law of landlords and tenants in Nigeria. We cannot exhaust it, that I know, but we'll just look at it, the ones that really concerns you as a landlord and the one that concerns you as a tenant. And today again, I have with me Barrister Desmond Oriakogba. Welcome.
Thank you very much.
I hope I pronounced that to your son
yes,
as well.
you got it. Well. You got it
I don't have a choice.
My name is Oriakogba.
Oriakogba. Yes. So, we're looking at the landlord and tenants today. It's a topic that I know that everybody is kind of interested in, especially if you are a tenant, going by what is happening in the life of a landlord and a tenant in our present dispensation. So, I'd like us to do a little bit of introduction here. Who is a landlord and who is a tenant?
The landlord is owner of a property. When I say a property now, I mean a real property. Okay, it could be a vacant land, it could be a land with a residential premises on, or a land with a commercial premises on. Okay, so that is who a landlord is. And a tenant is simply somebody who is allowed, who has the consent of the landlord to stay on that premises. And it doesn't necessarily mean that the person is paying rent, because rent in law is not a condition for the existence of landlord and tenant relationship. So somebody who is allowed to stay, who has been given possession of that property by the landlord, is the person we call a tenant. And these tenants, like I said, there are different types. You could have a tenant at will. Then you could have a tenant, a periodic tenant, who is either there monthly, quarterly, annually, as the case may be. That is who a tenant is.
And that is who a landlord is.
And that is who a landlord
is. In today's life of landlord and tenant, we know what usually causes problem. The issue of leave my house, I will not leave your house. Let's look at quit notice. How does it function?
The issue of quit notice arises where there is no where the landlord is saying, I don't want you anymore. For reasons usually, the reasons landlords usually give will be that I want to make use of my property, or I want to renovate. But essentially, quit notice is meant to terminate the relationship between landlord and tenant. That is what quit notice is meant to do. Once it is served, upon expiration of that quit notice, the relationship between the landlord and the tenant determines. That is one way the law allows a landlord to terminate the tenancy of a tenant. And the type of notice given to the landlord, to the tenant, or to be given to the tenant, to a large extent depends, first of all, on whether there is a contract between the landlord and the tenant. But when I say a contract now, I mean a written agreement between the landlord and the tenant. And because in most cases where there is such agreement, the tenant will, the parties will agree on the length of notice to be given on that side. And note this, it is not the landlord alone who can give a quick notice. I mean, who can issue a notice. Although the notice coming from the landlord's angle is a quick notice. The tenant can also give a notice to the landlord saying, I am no longer interested in tenancy by so and so date. At the expiration of this present tenancy, I do not intend to continue. And that has terminated the relationship. But it's just that in practice, or essentially, it is only the landlord who gives. And of course, that coming from the landlord to the tenant is usually termed quit notice. Now let's look at the type of tenancy before we go into type of notice. What kind of tenancy do we have? Because you talk about periodic, you talk about 3 months, you talk about 6 months. Yes, when we talk
because I want you to really expatiate on this.
When we talk of, I mentioned tenancy at will. A tenancy at will is one that, just as the name implies, somebody is allowed to stay on the premises at the will of the owner of the premises. I said, just be using it for at my will. I can wake up tomorrow and say I don't want you there anymore. But again,
you don't have to give a notice.
I don't have to give a notice to quit. I would get to the, because the law still places on me a duty to give some notice. and the law requires that I give 7 days notice
to a
that
tenant at will. Okay.
Leave my property in 7 days.
Within 7 days.
All right. So, but for periodic tenancy, which could be a monthly tenant, okay, a quarterly tenant, or an annual tenant, or a yearly tenant, the length of the notice differs.
Okay. Let's take it from the monthly tenant.
Okay, where there is no written agreement defining the length of notice to be given. Where it's a monthly tenant, is a month's notice that is required to terminate it.
If there's no written agreement, but there is an understanding of the method of payment, maybe I pay you monthly or I pay you every 3 months, would you not still give me
when we talk of method of payment here determines the... When there is no written agreement, I talk of method of payment. Method of payment goes only to determine the type of tenancy.
So it does not...
it does not determine the type of notice. You understand? When there's usually the written agreement determines, okay, this tenancy is going to be a monthly tenant, a monthly tenancy. This tenancy is going to be a quarterly tenancy. This tenancy is going to be a yearly tenancy. That is what an agreement does.
Okay.
And in the event of termination of this tenancy, either party is under a duty to give
notice.
A notice of 7 days.
Okay.
That is where there is a written agreement. For instance, 7 days. And in that case, when a case comes up, the first thing the court looks at is the written agreement. Okay. What parties are bound by the agreement.
Okay, for the purpose of understanding, if I'm a monthly tenant and you are my landlord,
all right,
how many days notice or how many months notice will you give me?
Where there is no written agreement.
Yes.
Whatever length of notice the agreement states, that is what the parties will be bound by. If the agreement says 7 days, you stand by that. But where there is no written agreement, then the tenancy laws will apply.
Okay.
And in such case, the landlord will be bound to give the tenant, a monthly tenant in this case, a month notice to quit.
Will the landlord still collect rent within that period of serving the notice on the tenant?
What is rent? That's the first question you should ask. Rent is compensation to the landlord for the use of his premises. Yes. So the fact that a notice to quit has been served on somebody does not, liberate him from his duty to pay rent.
He must pay rent.
He must pay rent. That is the reason why the landlord, when he takes the case to court, eventually takes a plaint in the court, in the magistrate court or the customary court, as the case may be, can still claim arrears of rent. There are some instances where a landlord and the tenant will be having an argument over quit notice and all, and you often the time hear tenants say, give me notice, we'll go to court. After 7 days and I don't leave, the court will still give me more days. I will still stay in this your house and I will not pay. For 6 months I will be in this your premises and I will not pay. As long as the tenant remains in the property, he is bound to pay rent. Most tenants make that, it's a misconception. They feel that once a notice to quit has been issued by the landlord, and then their stay thereafter becomes free. No. Once a notice to quit has been issued by the landlord, if it's a monthly tenant, as in the absence of a written agreement, if it's a monthly tenant, a month's notice. If it's a quarterly tenant, I think I should just go through all those. If it's a quarterly tenant, quarterly notice. If it's a yearly tenant...
When you say quarterly now, I would like you to break it down so that those watching will understand.
When you say a tenancy is quarterly, what do we mean? We mean it's, 4 months. All right?
Every 4 months, every 3
months, as the case may be. Okay, so the quarterly notice will take that same shape. 4 months notice. All right? That is what we mean by quarterly notice.
Okay. Then if you're a yearly tenant...
If it's a yearly tenant, 6 months notice.
And you must pay your rent within that
Once
period.
the landlord has issued you a notice to quit, at the expiration of that notice to quit, the tenancy terminates automatically. Now, the fact that the landlord gave you notice to quit does not mean that you will not pay rent for the 6 months that the notice is to last.
Okay.
You are obligated under the law to pay rent for that 6 months that the notice is to last. And where the notice expires, so long as you still remain on the property, you are also obligated to pay rent. All right? Because most tenants, what they will do is, okay, you have issued me notice to quit, no problem, but wait. At the expiration of the notice, it's okay, the law says, give me 7 days of notice of your intention to go to court. They'll stay. You go to court, you take them to court, they will employ the best lawyers in town to frustrate the case. The case will drag on. 6 months, 1 year, the case is still in court. And most of them do it under the misconception that so long as the notice to quit has been issued, they are not bound to pay rent. Under the law, a tenant or a person is bound to pay rent to the landlord for the use and occupation of the property. So as long as you keep staying there, you are obligated, and that's the reason why the landlord will be another will be made by the court, and of course an appropriate claim to make in a proceeding of such nature, as in for recovery premises, is for arrears of rent. Arrears of rent and mean profit, what some people call mercenary profit or men's profit. Okay, mean profit. And mean profit ordinarily under the law is to take effect for a statutory tenant, is to take effect at the moment when the court orders possession. When the court has formally granted possession to the landlord, it usually takes some time for the order to be executed.
Okay.
All right. Mean profit is starts being calculated from that moment. Although there are some authorities which say that mean profit starts from the moment the landlord serves the tenant the plaint. All right, that is the court process. Okay, but authority, the best authorities are to the effect that it starts calculating from when the court issues the order of possession, and the tenant still remains in the property. From then on, it becomes obligated to pay mean profit, and mean profit is simply intermediate profit. Now we will not be talking about arrears of rent anymore. But we'll be talking about the entitlement of the landlord, the compensation of the landlord for the use of the property from the moment when the court has given the order of possession. Okay, so I'll go back again. Like I said, it is a wrong misconception for a tenant to believe that he is not obligated to pay rent where a landlord has issued him a quit notice. The appropriate thing to do is for the tenant to wait at the end of the notice. While waiting, he is looking for another property. For alternative property, so that at the end of the quit notice, even before the end, he could decide to say, okay, I am leaving your property. Okay, so at this point we quickly take a break, and when we come back we will continue with the topic on law and you, which is the law of landlord and tenants. For participation, just use the email address on your screen, and of course our Twitter handle. Use them freely, and contribute to the program Law and You on any topic, on any issue, on any case. We'll be here to answer. We'll take that short break now.
The DPO comes in the morning and says, "What are you doing at the police station? What are you doing here? What are you doing here?" And you say, "I was arrested." Who arrested you? John arrested you. Call me John. Why did you arrest this man? If he cannot give an account to the DPO why he's arrested, the DPO asks you to go.
The appointed gun as someone, he gets frightened. It is battery, even though no physical injury has been suffered.
Citizen of a country, you have all your fundamental rights intact, and nobody, including the police, can subject you to extortion and inhuman treatment.
It's nice to have you join us again on Law and You on Independent Television this gorgeous Monday afternoon, and we're looking at the law of landlord and tenant in present dispensation in Nigeria, in Edo State, wherever it is that you are staying. We are looking at the law of landlord and tenant, the law between you and your landlord, and the one between your landlord and you. And Barrister Desmond Oriakogba. Now, let's look at this issue of taking laws into one's hand. A landlord has issued quit notice to a tenant. After the expiration, he has issued him another 7 days notice of, intention to go to court. And probably he went to court, all things being equal, he gets judgment against the tenant, and the tenant is still in the house. How should he take possession? Should he go remove the roof of the said property, or go destroy some part of that said property? How should a landlord recover or take possession of a premises?
First of all, the law frowns against self-help.
Okay.
In fact, that is why the courts are there, to ensure that we do things properly. We don't take laws into our hands.
But that is what happens every day. Most landlords will go take off the roof of a house.
Well,
or use twerks.
It is wrong in law. It exposes the landlord to a claim for damages in trespass. Because a tenant
even
can
after
sue,
he has gotten judgment from the court.
a tenant can sue judgment. The fact that you have gotten judgment from the court does not lay the matter to rest. There is a procedure for enforcement of your judgment. Okay, you got order of possession. You would go ahead and take the necessary, put in the necessary papers and get a writ of possession, and you go ahead and execute. There's a procedure for execution of judgment.
So let's look at that procedure. What are these procedures?
It's simple. You get, after getting your once the court has granted you the order of possession, it does not lie in your hands to pick up talks, go there and begin to bulldoze. Usually the order of the possession the order would stipulate, usually require you to go there with some police officers of particular ranks, and you are expected to go ahead and draw out a writ of possession. Okay, get a writ of possession, and once the writ of possession has been properly entered by the court, you get the court will usually gives you some court officials, okay, and then with some police officers, and you go ahead and execute your judgment. However, there